Great. Well, thank you for joining us and welcome all. We're gathering to celebrate the anniversary of the day the 39 delegates to the Constitutional Convention signed the Constitution, September 17, 1787 in Philadelphia. This is not the only event commemorating Constitution Day. Yesterday, we had a fabulous symposium with Professor Timothy Waters discussing his new book on secession and international law. And the American Constitution Society held a webinar on local and federal government conflicts in times of crisis. In some ways, Constitution Day has a particular importance for universities. Great universities and great law schools thrive on intellectual debate, on the open exchange of ideas and the service of learning and the creation of new knowledge. Constitution Day for us has always been an opportunity to learn a little more about our own history and the rule of law, and to hear from leading thinkers on some of the great issues of the day. I'm very pleased that today we continue that grand tradition of intellectual engagement with our keynote speaker, Professor Bill Eskridge. Before we begin, I've been asked to let you know that the chat function will be disabled during the lecture, and attendees should utilize the Q&A feature when asking questions. We encourage you to ask questions or write questions using the Q&A function, and we'll then field those questions after Professor Eskridge has finished his talk. At this point, let me turn over the podium, so to speak, to Professor Charlie Jay, who will introduce Professor Eskridge. Again, welcome.
Good afternoon, everyone. William Eskridge is the John A. Garver Professor of Jurisprudence at Yale Law School. After graduating from law school at Yale, Bill clerked for a federal judge and did a stint at the Washington, D.C. law firm of Shea and Gardner before beginning his teaching career at Virginia, then Georgetown, and now Yale. While at Shea and Gardner, Bill met the late, great Philip Fricke, and together they assembled materials that would be published as the casebook entitled Statutes and the Creation of Public Policy, which combined with a blizzard of law review articles Bill published in the 1990s would redefine the field and establish statutory interpretation as its own subject of study. Likewise, in the early 90s, Bill expanded his repertoire, representing a same-sex couple in their failed effort to win marriage rights, which led to the 1996 publication of his book, The Case for Same-Sex Marriage. That book was derided on the floors of Congress when it passed the Defense of Marriage Act that same year. 2 decades later, after the Supreme Court had invalidated both the Defense of Marriage Act and state laws barring same-sex marriage, Richard Posner would write, quote, "A prophet before his time, William Eskridge has the satisfaction of having finally been vindicated." Earlier this year, Bill and his co-author, Christopher Riano, published a new book with Yale University Press entitled Marriage Equality, From Outlaws to In-Laws, perhaps one of the best titles in the history of titles. I got to know Bill in the early 1990s when he was at Georgetown, and I was counsel to the House Judiciary Committee. And as an aspiring academic, my thoughts turned to Bill as a potential role model, but I quickly realized there's no way in hell I could emulate his level of productivity without cloning myself 3 times and foregoing sleep. If Bill was going to be one of the 10 most cited legal scholars in the country, and he is, he could at least have had the decency to be an arrogant and insufferable pain in the ass so that others might find solace in marginalizing him as a lousy human being. But no, he's one of the sweetest and most generous people I have met in 35 years of professional life. Here today to give a talk entitled Indiana and Marriage Equality, I give you the groundbreaking, the resilient, and the inimitable William Eskridge.
Thank you very, very much. It's a pleasure to be here, in part because I probably am insufferable to some people, but Charlie was an absolute peach to work with on the Judiciary Committee and is responsible for a lot of excellent legislation and oversight, much more productive than I've been in those fields. And then Deborah Wittes has herself been redefining both legislation, where she's been a very productive, younger, recent scholar, but also sexuality, gender, and the law. So we share that with these 2 of my most esteemed colleagues in the academic world. So it's just such a great privilege. Now I'm going to share, if I could, my PowerPoint, which I've entitled it, How Marriage Equality Prevailed in Indiana and Everywhere Else. Our book does perhaps churlishly focus on states like California, Massachusetts, Hawaii, a little bit more than Indiana. But I think, as you'll see from these slides, the theme of our book, which is a conversation, Charlie says, it's a great title. We like the title. It's from Outlaws. And here's the Outlaws part. When I was growing up, this is my perception in public culture, without reading a lot of government documents, that we were not known as gay men and lesbians. We were known as homosexuals and other sex perverts. Consensual activities were a crime in every state, a felony in almost all of them. The medical science people labeled us, as well as the government, as mentally ill and indeed psychopathic. And of course, the government would not employ us. That's where we were. This is the model for both society and government policy in the 50s and 60s when I was growing up. And it's the natural law model that whatever your biology was, and it was binary, either a man or a woman, that both did and should define your gender characteristics and your characteristic or preferred sexual activity. And the law enforced that natural law norm with a vengeance. The big challenge in my youth to the natural law norm was here at Indiana. And in my prior work, Dishonorable Passions, the centerpiece of that work is the Kinsey Reports, what are popularly known as. One for men and one for women, they're pictured. And the Kinsey Reports did many spectacularly important things, but two of them were the following. As a descriptive matter, the Kinsey Report said there's a lot of variety in gender. There's huge variety in sexuality. And Americans of all orientations engage in a wide variety, almost all of it illegal, of sexual activities. Most of it outside of marriage, most of it not conjugal. Normatively, and this is not a subtle message, this is explicit in the pages of both Kinsey Reports. Normatively, Alfred Kinsey and his brilliant colleagues at the Institute argued that sexual variation is a natural and benign phenomenon and not one that should be denigrated. And of course, he backed it up with all the descriptive information. Now, there he is at the Institute. At the same time, Indiana was making this enormous contribution to our understanding of sexuality. Feminist thinkers and philosophers, and I emphasize Simone de Beauvoir, whose brilliant book, The Second Sex, is a Magna Carta for the idea as human beings, men and women must ethically be considered equal in their human rights. And the La Différence in France ought not to obscure that. Yet, she points out, Plato and subsequent thinkers have assumed that man has got to be the measure of all things. And de Beauvoir says that is inadmissible philosophically, that a man as subject and the woman as other is not philosophically defensible. And then her book, among many other contributions, is a leading statement of the disconnect between the natural law idea of sex as biology and sex as gender. And summarizing the French, one is not born, but becomes woman. In other words, woman as a gender is socially constructed. In the United States, Betty Friedan translated a lot of these ideas in a popular book to an American audience. And she seized upon de Beauvoir's theme of an independent woman into an American context, that to be an independent woman, independent human being, she must separate herself from the male ideals embodied in public culture and should not be bound by cultural assumptions about feminization. In 1966, Betty Friedan with Pauli Murray of my law school founded the National Organization for Women, and there have been many organizations since then. And then finally, in terms of the context of the marriage debate, and this is where our book starts, are Mildred and Richard Loving, the civil rights movement. That's Loving versus Virginia, obviously. And so when I was growing up, I actually did not subscribe to the natural law view that homosexuals and other sex perverts were inferior human beings with no human rights. I was very much inspired, even as a kid, an adolescent, by Loving versus Virginia, by the civil rights movement and Dr. King, and by Thurgood Marshall, who argued that racial groups should be not be subject to subordination, and race should be a suspect classification. And Loving was kind of a Magna Carta for marriage rights, which the early marriage activists seized upon. The women's rights movement opened up employment opportunities for women, which was extremely important for what would become the LGBT rights movement. And it also inspired the first big marriage proposal by Thea Spire with Edie Windsor, which becomes important later on. It also inspires the first federal marriage lawsuit, that in the civil rights movement, the Donna Burkett and Menonia Evans lawsuit in Wisconsin. And then at the same time, gay men, bisexuals, and transgender persons were starting well before Stonewall to push back against police harassment. And in the same year, Thea Spire proposes marriage, Jack Baker proposes marriage to Mike McConnell, and they become the first marriage celebrities. Now here in the Midwest is a hotbed, not of rest, but of marriage activism in the 1960s and the 1970s. In Kentucky, just across from you all. In Minnesota, that's the Baker and McConnell couple. The Institute actually provided important advice to them and provided an expert witness, though the hearing was canceled by the judge because of a procedural technicality. And then the very important Wisconsin lawsuit by Burkett and Evans. Well, unfortunately, as we document in detail in our book, all of the early cases lost. Not a single judge voted for marriage equality. And then the AIDS epidemic of the 1980s shut the door. And some ministers and other leaders understood homosexuality during the AIDS epidemic as a Trojan horse polluting America with disease as well as immorality. And that's an essential background to Bowers and Hardwick, as I argued in earlier books. But just as AIDS created a bad atmosphere for our assertion of our rights, it also created a renewed interest in committed relationships and gay marriage. And Lambda Legal, the oldest and most active of our litigation organizations, actually debated, Tom Stoddard on the left, Paula Edelbrick on the right, should marriage in the late 80s and early 90s be an important goal for our movement? And Stoddard, who thought that the late 80s was too early to actually bring lawsuits, said we should be actually looking ahead and making marriage a primary goal. Edelbrick, and I was very good friends with both of them, and I was on the marriage should be a priority. But I think Paula Edelbrick was both brilliant and characteristically correct in her criticisms, and these were the following. She argued that straight people were perhaps right, that marriage is founded on patriarchy and conjugality. And to the extent that was the cultural and social basis for marriage, it was not going to be receptive to LGBT people who cannot procreate inter se. Instead, Edelbrick argued, and very persuasively and very importantly, as we document in detail in our book, the LGBT rights movement should have as its agenda family formation and recognition and support for that outside of marriage, like second parent adoption, where Edelbrick, Nancy Polikoff, and others were pioneers. Alternative family forms like domestic partnership. Edelbrick was very important in getting that recognized, for example, in New York City. And protections and benefits for cohabiting couples, not just for marriage couples. And then she also argued, and this is more controversial and more clouded, but very importantly, that marriage would crowd out other items in the agenda, such as job protection, sodomy reform, and hate crime, which should be bigger priorities, particularly for the lesbian feminist community. Now, notwithstanding the debate within Lambda, which was not going to bring its own lawsuit, the plaintiffs came marching in. I represented the DC couple, which filed the first lawsuit, actually. But the biggie was Hawaii, where Janora Dancel and Nanita Bayer and two other plaintiff couples filed the first big marriage lawsuit in 1991. As is very famously known, the Hawaii Supreme Court in 93 made the front page of the New York Times by ruling that same-sex marriage bars in Hawaii were a suspect classification, required strict scrutiny under the Hawaii Constitution, not the federal Constitution, but the Hawaii Constitution, which had an ERA in it, unlike the federal Constitution in the 1990s. On remand in 96, Judge Chang there on the left ruled that the state had not met its burden of justification. The first big gay marriage trial, there's a littler one in Kentucky, the aborted one in Minnesota. The first big one is Judge Chang's trial in Hawaii. Now, while that was on appeal, a coalition of Latter-day Saints and Catholics formed an alliance which persuaded a begrudging legislature to put it on the ballot. And 70% of the voters in gay-tolerant Hawaii voted to recognize only different-sex marriages or allow the legislature to do that. A big defeat for our side, but the debate has been entered. Now, ironically, there were a lot of side effects, most of them bad, for the Hawaii lawsuit. Paul Revere of the traditional marriage group, Phil Burris, also here in the Midwest, most of the activity for a while occurs here in the Midwest in neighboring states. He's Cincinnati, an anti-porn activist, hears from his buddies in Hawaii, hey, if we get gay marriage in Hawaii, which in 1995 seemed still possible, then it's going to also force to be recognized in Ohio because of the full faith and credit clause, which was false, but the gayocracy was saying that in memos that were leaked to Republicans in Congress and to the Burris group. And so off he goes, and in Memphis, which is not quite the Midwest, but it's the Sixth Circuit, right next to y'all, the Memphis group forms in January of '96 and authorizes the drafting of a federal marriage amendment, which is launched at the GOP Iowa caucuses in February. And there you have it. There's the Defensive Marriage Act. Indiana starts assuming the central role that it's going to assume in today's talk, that a key supporter, and one of the more moderate ones, I might add, is Senator Coates, who served a couple of different times in the Senate from this wonderful state. And unlike most of the supporters in the House of DOMA, Senator Coates says, rather than brutal gay bashing, he says, well, this is really to reaffirm the traditional definition of marriage with all of its virtues and as a stance against, in his language, trendy moral relativism, which is about as nice as the rhetoric gets in favor of DOMA, including rhetoric from the White House. It's passed with overwhelming support from the Democrats as well as the Republicans. The Pillsbury Doe president signs it into law in September of 1996, and indeed relies on it in his campaign for re-election. So here's an irony, and it does not apply to Senator Coates, whom I deeply admire. But the big supporters of DOMA, Speaker Gingrich in the House, Majority Leader Dole in the Senate, who ultimately was going to be the presidential candidate, and President Clinton in the White House, were the three big supporters of DOMA. And you had the spectacle of the nation's three highest-ranking adulterers declaring themselves protectors of marriage against committed lesbian couples, like one of the Hawaii couples, raising children in a responsible, committed relationship and not engaging in adultery, betrayal, et cetera, et cetera. It was a sad moment, and as Charlie pointed out, my book was used as ammunition in the Senate side, not again by wonderful Dan Coates, but by my own Senator, Robert Byrd, who read extensively from my book. There we are again. The House Judiciary Committee basically pitched DOMA as no promo homo. Again, not Senator Coates's defense. There were very few speakers against it. The most notable one and most eloquent one is the late Representative John Lewis, who very bravely called out DOMA for what maybe it was, and that is intolerant and an acceptance of bigotry. And indeed, John Lewis made the point that gay people were almost afraid to make in public, that actually respecting families like the Hawaii families would be worthy of marriage and would not be any kind of attack on it. Notwithstanding DOMA and other defeats in the 1990s, one of the things the Hawaii case did, it did put marriage equality as an achievable agenda item for LGBTQ people. And many people who never even thought we could have our relationships recognized actually felt, well, maybe we can, notwithstanding all of the opposition. And the Vermont lawsuit came close in 2000 and 1999. But the big achievement, it seems to me, what I call our Cinderella moment in the book, is in November of 2003, when Chief Justice Marshall, that's Margaret Marshall on the left, delivers a 4-3 judgment in favor of Mary Bonato there on the right, who represented 7 lesbian and gay couples and a boatload of children in the challenge to Massachusetts. There you see Mary in the center. To the right of her is Annie Goodridge, one of the boatloads of children being raised in these committed relationships, non-adulterous, et cetera, et cetera. And then her parents, Julie and Hillary Goodridge, further to the right, also looking quite delighted. So obviously they're celebrating their great victory. Now, we don't get marriage licenses in Massachusetts actually until May of 2004, and we have a whole chapter on the brouhaha debate within Massachusetts trying to override the marriage equality. But it sticks, and so Massachusetts is the only red state, the only recognition state for several years. We do have alternative institutions, civil unions in Vermont, domestic partnership, comprehensive in California, and less comprehensive reciprocal beneficiaries in Hawaii. Moreover, at the height of all this, in the wake of Goodridge, the moribund federal marriage amendment drafted right here in Indiana, more Indiana, Professor Bradley just down the road, Professor George at Princeton, Marion Glendon at Harvard, drafted the federal marriage amendment, was introduced in Congress in 2002, but didn't really get going until after Goodridge. And there you get George W. Bush, and we have a whole treatment of the Bush family drama over the federal marriage amendment. Let it be said that I don't think any member of the Bush family was very enthusiastic, and some were outraged. And indeed, the president looks vaguely uncomfortable or nauseous as he's making his endorsement of the Defense of Marriage Act. The federal marriage amendment doesn't go anywhere and even loses a lot of Republicans, such as Senator McCain. Though I think the Indiana senators, Republican senator voted for it. They're not coats at that point. Now, at the same time, we're getting the federal marriage amendment. We're also getting a new round of arguments in the state constitutional cases, because the cases are all state constitutional law. They're not federal constitutional law at this point. And we call them in a whole chapter the latter-day constitutionalists, most of whom ended up being very good friends of mine and were great sources for the book. My best friend in the whole thing was Maggie Gallagher, who was the most hard-hitting opponent of what we were doing. And she and I became warm friends before, and then after Obergefell became even closer, and she was very key to the book. Now, the arguments that were developed originally by Maggie Gallagher, but in legal terms by Monty Stewart there on the left and Lynn Wardle there on the right, ultimately became tagged as the responsible procreation argument. So no longer was the main argument, the DOMA argument, that this is moral relativism, very bad, that these are icky people, very bad, we should take a stand against homosexuality, very Sodom and Gomorrah, judgment of God, stuff like that. The new argument became, hey, let's not denigrate the gays so much as make it all about what is marriage actually for. So make it positive. Now, the opinion polls were telling the other side, if you denigrate the gays, it's going to actually hurt you, and you're going to lose the moderate middle. So you need to run for the middle. And so you need to come up with something kind of neutral. And so the neutral thing was, the point of marriage is that those rascally heterosexuals, there's just no telling what they will do when left to their own devices. Even when they're careful planners, which they usually aren't. Now, these are all stereotypes. And we do not, in the book, subscribe to any of the stereotypes about heterosexuals that were being advanced by this. But this was the argument. So they need an incentive, and they also have this accidental procreation. So they need an incentive, if they accidentally procreate, an incentive either to get married to start with and get all these goodies and benefits, or if they're rascally and unmarried, then, and the accidental procreation occurs, then they get married as soon as possible to get all these goodies and benefits. And so the good thing about this argument from that point of view is that it sounds more neutral. It not only doesn't sound anti-gay, but it actually sounds kind of gay okay. That the lesbians are kind of responsible. They're too responsible to need marriage, right? So the needy, okay, you see what I'm saying. Well, okay, I think that's an odd argument, but it did have the advantage of being less homophobic. Well, Indiana is in the forefront. Indiana, the lead case is Morrison versus Sadler. They pick up on it, Monty Stewart's amicus brief. They just like download it. Here it is, accidental procreation, very nice to the gays, so on and so forth. Here's the judge. He's Indiana, Notre Dame JD. So not Indiana JD, okay, but Notre Dame, also right down the road. They'll follow Indiana. And most of them decide Morrison and Sadler. Hey, let's follow Indiana. It's not even the Indiana Supreme Court. And so they accept the responsible procreation argument. So by the end of 2008, and I should have added Connecticut in there, very end of 2008, Connecticut comes on board. You have two marriage states, Massachusetts and Connecticut. And then you have all these others with some kind of usually watered down domestic partnership. But here's the interesting thing that goes on, is that even as my side is losing pretty much all the cases, Indiana wins, Eskridge side loses, except for Massachusetts. Public opinion after Goodridge continues to tick up about 2% a year, and opposition down 2% a year, as it becomes more and more talked about, even without a lot more states, just still Massachusetts, it becomes more acceptable and less despised, I guess. And so we were bound to start winning some. The election of President Obama was like a big deal in that respect in November 2008, but we lost, Prop 8 on the same day. We did start winning cases and winning this and winning that. A very big deal, again, the Midwest. Again, not Indiana, I'm sorry, but Iowa. Who'da thunk it? The big turning point after Goodridge is a 7-0 decision in Iowa. And these four people pictured are all plaintiffs. The two children are plaintiffs, as well as the lesbian couple raising these two wonderful children. McKinley there is on the far left. That's a big deal. Then we actually start getting legislation. Now, again, not in Indiana, but we get legislation in the Northeast, in DC, and in New York. Judith Kay, Prof, though in dissent in New York in 2006, and Governor Cuomo, Alfonso David, who was his counsel, and a number of other supporters within the LGBTQ community, engineer a very dramatic victory in the New York legislature in 2011. Very big deal. Superseded only by the president himself, who comes out of the marriage closet in May of 2012 and announces to Robin Roberts and a not too astounded nation that yes, he and Michelle and the children and whatnot are in favor of marriage equality. When he does that, this is May of 2012, you notice the jurisdictions have lined up much better from my side. The black ones, you got a fair number of marriage equality jurisdictions, though two of them, Maryland and Washington, we kind of count them because they pass statutes. But everybody knows those statutes are on the ballot in November and can be revoked by a majority of the voters. So they're kind of tentative. Maine, up there in the top, we list as just a domestic partnership jurisdiction, but it has on the ballot in November of 2012 an initiative to upgrade Maine to marriage from domestic partnership. And Minnesota, they're white in the middle, has a constitutional amendment to bar marriage equality entirely. Now, we win all those cases. We win all those elections. President Obama wins re-election on a marriage equality platform, etc. His Solicitor General joins forces with Edie Windsor. Remember her marriage proposal back in '67? Well, Thea Spire, her long-term partner and spouse, dies. They had a Canadian marriage recognized in New York. Edie sues. She gets hit with a big tax bill that if they recognized her legitimate marriage, she wouldn't have. And she wins in June 2013, a 5-4 verdict in the Supreme Court. And DOMA is dead, basically for the reasons that DOMA was created. It's anti-gay and really does not represent neutral policy. Now, always helpful to the LGBTQ cause, Justice Scalia, in a Cassandric dissent, said, if you believe everything in the majority opinion, then the state laws all fall as well. And okay, that was a very nice point, Nino. But to hammer it home, he actually took paragraphs of the majority opinion and edited them for Lambda and ACLU. So you just edit them in a few words, and this becomes your argument for the Arr! And the Chief Justice is sort of like shaking his head, holding his nose, etc. And there you have it. So here Indiana is again. So Indiana, very much smart people, great plaintiffs, smart lawyers, bunch of cases. So it comes out of the woodwork, Indiana cases, all downloading Justice Scalia, says, okay, here's the argument we make, et cetera, et cetera. One of the cases is Baskin versus Bogan, and it gets jumped ahead of the others. This is all after Windsor, because everything becomes federal now after Windsor, because one of the plaintiffs in the case has what would ultimately be terminal ovarian cancer. And so they got an advanced expedited schedule. Judge Young granted them an injunction. Governor Pence very lawfully accepts the ruling, but then he tells the agencies to ignore it. Again, more Indiana. Goes up on appeal. The very zealous Indiana Attorney General, Zeller, takes an appeal to the Seventh Circuit, where his minions are humiliated by one of the hottest benches I think I've ever listened to. It was not there, but I've listened to it. Ann Williams, left. Dick Posner, the Dickster, center. David Hamilton, Indiana University, Bloomington, they're on the far right. Well, Indiana was not quite ready for a bench asking questions. So a cranky judge said, well, there are 3,000 children adopted by LGBT parents in Indiana. Wouldn't they be better off if their parents could get married? Asked one of the cranky judges. And the Indiana Attorney General, blah, 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 oh, no. And the judge says, what do you have against these children? Why do you hate these children? Well, that was not so good. The less cranky judges also humiliated the Indiana Attorney General's office. One of the sweeter judges, Judge Hamilton, at the end kind of said, well, okay, the non-marital births in Indiana from 1990, anti-gay, to 2014, soared by like almost 2/3, more than 2/3 actually. So was this procreation policy, this anti-gay procreation, was it there to actually encourage responsible procreation? Or was it there because it was just anti-gay? More drooling by the Attorney General's office. And then the bench also asked, they said, hey, Indiana allows first cousins cannot marry at all, no marriage, unless they're over 65 and couldn't procreate. So why are you gonna like go out of your way to allow non-procreating 65-year-old cousins, but not allowing lesbians who are actually raising children that they have a biological connection with in a loving, connected home? Who knows what they were thinking, says the Indiana Attorney General. Okay, well, they lost. It took the Seventh Circuit about a week to write a lacerating opinion, blah, blah, blah. That's bad enough. So then Indiana appeals, naturally. At the same time, their appeal is going on. Virginia is appealing a Fourth Circuit ruling. And at the same time that's going on, Oklahoma and Utah are appealing rulings of the 10th Circuit. So you've got all these states, a whole bunch of cases, and Supreme Court on October 6, 2014, the Supreme Court denies review, discretionary review, of course, in all 5 sets of petitions. And then there's Wisconsin too. So there's 5 different states, clusters of plaintiffs in each state. 6 justices said no to the petitions. And then the next day, the Ninth Circuit also denies. Here are 5 of the 6. We're not going to tell you the 6. You have to read the book. And this overnight, by November, creates marriage equality almost everywhere. It looks a lot like the Loving versus Virginia map, mostly the same states. Then you get Obergefell, as well known. Midwest again. Ohio, there are the plaintiffs and Aunt Paulette. There's Mary Bonato again. There's a guy who disrupted the oral argument. I was there. He was a couple rows behind me, shrieking anti-gay epithets. After he was dragged from the courtroom, you could hear him in the hallway screaming. Justice Scalia said, well, that was actually quite refreshing. and for the dozens of LGBTQ people in the courtroom for whom violence had often followed immediately from such language. And in my case, being denied tenure at the University of Virginia followed exactly from such language, where I was called a faggot by the chair of the Appointments Committee of Virginia. It was not considered amusing or refreshing by those people in the courtroom. Justice Kennedy delivered the opinion for the court. The mastermind was Justice Ginsburg, who inserted a lot of the equality arguments as we document in our book. We ask at the end, why did marriage equality prevail so swiftly between, say, Goodridge and Obergefell? That is very swift in terms of American constitutional law. And we offer some ideas in the book. One is that Goodridge, the Hawaii case, but certainly after Goodridge, stimulated a lot of what we call pop-up homosexuals. A lot more people came out to their families, coworkers, etc., not only as LGBTQ people, but as committed couples, very often raising children, and so on. And indeed, the whole template of LGBTQ people began to change. These are not narcissistic, irresponsible, cultured hairdressers, but these are people who actually have connections, often families, and they're connected with larger families. And that became more legible to other Americans. And here's an example. This is one of the Michigan cases, more Midwest. April DeBoer, Jane Rouse in Michigan. Focus of our book is this couple and their children. These are 3 of their 5 children. And they're doing a wonderful job. Moreover, after we actually started getting marriage in Massachusetts, Connecticut, and other states, it falsified predictions that were made. It did not harm marriage. It did not lead to more irresponsibility on the part of rascally heterosexuals. Marriage rebounded. It didn't harm people by and large. And then thirdly, that straight people, one of the big themes of our book is the big variable in our book is not gays and lesbians. It's the role, social status of women. Between 1967 and 2017, women's role, economic opportunities, rights, and whatnot in our society changed dramatically. Women's preferences and status and whatnot changed family, changed marriage, and gay marriage was a byproduct of that. Okay. And indeed, male-female households were more like, this is one reason why our households were more legible, because other households were more like LGBTQ families we choose. 2-income households, a little bit more division of labor, planned families, blended families, et cetera, et cetera. Today, our book ends with some of the couples today. Baker and McConnell still together. They're legally married. Their 1971 legal marriage was finally recognized in Minnesota. Good for them. Here's some of the other couples, people, Donna Burkett in the top, Paul Barwick, who was a Washington plaintiff. Janora Dansel is married to another woman. Anita Bayer is legally married as well. And then here again, our star couple, Jane and April, the DeBoer Rouse household. But they didn't see their marriage as just like a commitment between the two of them. It was also a vertical commitment. We're committed to each other, but we're also jointly committed to the children. And so their marriage was a marriage to their children as well as to each other. And that's Ryan, their oldest daughter, her hand. But it all goes back to Indiana. Gay marriage was like a minor issue in the 2016 campaign. It was, based on my interviews all across the Midwest, it was a major issue with many evangelicals who support Governor and then Vice President Pence. And they did provide a lot of votes for that particular ticket. So you could argue this is either Governor or Vice President Pence in an evangelical service where the point of the service was literally the demonization of homosexuality. It was equated with demonizing. There is CLE credit. I hope you can see the number that you get. And this will be available, unless Deb corrects me, this will be available on the website for people to view. The Kinsey Institute continues to do pioneering work and has been absolutely critical all the way through for documenting the natural variation in sexuality, the benign variation the many different roles that sexual and gender minorities play in American society. And your work has never been more important, in my opinion. And then there's, of course, this book that just came out a few weeks ago, which tells you, we think, a riveting and fascinating story. And I will put this plug. By middle-aged gay white men. That is false. It was delivered by a kaleidoscopic coalition of straight people, particularly straight women, of civil rights communities, people of color, African Americans, Latinx Americans. Black Lives Matter, not just generally, but they matter to our movement, as well as to transgender persons who've been completely ignored in other histories. So our history does purport to be, if not the only complete history, it's certainly the most complete history of the discussion, including the opponents. And people like Senator Coates and Barnes and other Judge Barnes did contribute to the dialogue, and our book does appreciate their contributions as well. So thank you all very much for your attention. And I'm going to take down the PowerPoint if I could.
Thank you so much, Bill, for a wonderful lecture and amazing job consolidating a now 50-year story or so down to 40 minutes. So I just want to remind people that the Q&A is open. We would love to answer questions. Bill, because he did do such a good job consolidating it within the 40 minutes, we have a good amount of time for questions. And I also want to say personally, thank you to Bill for those kind words at the beginning. And it may not be a coincidence, because I was lucky enough to have Bill as a teacher of mine when I was in law school, that I now research and study kind of exactly what he does. So it's a privilege having you here. I would love to start by hearing you think about what clearly is coming in terms of the court struggling with religious exemptions. The case that's on the docket for next year concerning foster care, Bostock leaves open quite explicitly the idea that there may be exceptions from the protections that it announces from employment discrimination for religious employers. And I guess I'd like to hear your thoughts both on what you think the court will do, but also what you think the court should do, because I think you've thought really deeply about how to balance these competing interests.
Well, Deb, I appreciate that question. The only correction I'll issue is that Professor Wittes has very much deepened the projects that I was involved in, and her work on the interpretation of congressional overrides, Supreme Court opinions, was surprising to me and others. It was dispiriting. It was brilliant, and it's classic. It remains the work, and you've done some articles, etc. So Fulton, let me start with that. That's the Philadelphia foster care case. That might be the easier one for me, although again, prediction, Lord knows. The key thing about Fulton, in my opinion, it was a government program. The city of Philadelphia took governmental responsibility for foster care, both placing, evaluating, paying, etc. And Catholic Services was working for the municipality. It was being paid by the municipality. And honestly, I think it would be very bad news indeed if the Supreme Court were to hold, contrary to the Third Circuit, that they have to accommodate Catholic Service in saying we're not going to, as a state program or a government program, we're not going to do business with gay and lesbian legally married couples. So I think the should on that one is clearly they should not accept the claim there. And maybe they'll come with some compromise. And prediction, I guess I would be surprised if they accepted simpliciter, the Catholic Services claim. I think much more difficult going to be claims by, like, say, a Hobby Lobby, like a private company, closely held perhaps, or partnership, where the people controlling it are deeply religious for sincere religious reasons, feel they cannot accommodate. By the way, I also don't think it's not a hard case, religious institutions. I think if a Catholic seminary or a Baptist seminary are not going to accommodate. Well, first of all, Title VII has exemptions for them, but I think that's defensible. The difficult ones, I think, are going to be like Hobby Lobby. And there, I do think Justice Gorsuch all but said that RFRA, Religious Freedom Restoration Act, is a super statute that is probably going to accommodate Hobby Lobby. So I think that's the probably will do. What should they do? Well, our book actually is more procedural. Here's my honest opinion, and this is not to disrespect the opinion of everybody else who writes on it. Almost all the law professors who write on this issue come forth with a theory of fairness that they believe, and it's based upon perfectly legitimate theories, Rawls or the Bible or whatever. In our opinion, there is no reason for judges to listen to law professors' theories about fairness. And our view is that what judges should do is hew to precedent. We lay out a precedent-based case for a narrow judicial role, and that judges should be very attentive to legislative action. And honestly, our view is that legislators, and the example we use is Utah in 2015, adopted a very red state, an anti-discrimination statute, gender and sexual minorities, but with religious allowances that were worked out in a dialogue among businesses, the Church of Jesus Christ, and the LGBTQ group in Salt Lake City. And I think it was a statute of principles. And I'm supporting the movement in the state level to try to work out other statutes like that. Now, Indiana went a different way, as we know. But I would love for a state like Indiana to try to work out some kind of statute along those lines. And I think that would guide the courts in trying to thread the needle between our book. I myself am religious. I myself think most religious people do not want to discriminate against LGBTQ people. When I was called a faggot at Virginia, it was not by religious people. It was by unreligious people. Okay. So I would like to see conversations. So our book is, we have a whole chapter called The Golden Rule. And our view is the only way forward as a nation is for each side not to just treat the other side as it would want to be treated. That's the golden rule. But in my opinion, here's Jesus's deeper meaning of the golden rule. And that is understand the other person before you make a decision, how would I want to be treated? You can understand yourself, but understand the other person as well. And our book does make an effort along those lines.
Thank you. I want to flag for people that are getting CLE credit that the code is now repeated in the chat. And then I want to ask you a question that looks from the Q&A that looks beyond the borders of the US and asks about how the marriage equality fight here has influenced or perhaps was influenced by constitutional litigation and social movement developments in other countries, particularly in the global South, but more generally as well.
Great question. And our book, doesn't have much to add to that, but here are my views. Odd thing is, marriage equality has come almost everywhere else by legislation. And it's mainly we've been influenced by other countries. I said I represented the plaintiffs in the DC case. They were inspired by the Denmark registered partnership law. And to some extent, so were the Hawaii people. That say, hey, a country's legislature can actually recognize lesbian and gay unions, though not as marriage. And then marriage, as you know, came earlier to the Netherlands, Belgium, Canada. Canada, that's where Edie and Thea were married, in Canada. So I think we were very much influenced. Now, I was an expert witness in the Canadian marriage litigation stuff. And so I was very much involved in the Canadian stuff, but it was legislative. They won some court victories provincially, but it was Parliament that delivered marriage equality to the entire nation in Canada. So I think that's one lesson. And that was one reason I was so interested in working on legislation and not just litigation victories. So that's one lesson. To what extent has the United States sort of been influential? Well, we're a very big deal. We're considered kind of a backwards country in many ways. And for the United States, it's to recognize this I think Lawrence was a big deal. We have a whole chapter on that in the book, the consensual sodomy law case out of Texas. And that's been widely quoted and emulated in other countries. So again, Justice Kennedy told us to our faces. He said, I was inspired by Dudgeon, a European case. Kennedy said, I was ashamed of Bowers after I read Dudgeon. And I did a class on Bowers and Dudgeon. And I was ashamed before I was on the Supreme Court. So I think the influence has been mainly from abroad to the United States. But then, we have had a positive influence in the world. And you see countries all around the world, including in the South, Argentina, for example, Colombia, countries in the South, also either by litigation or legislation or some combination of the both, following through. And I think a lot of it is, it emboldens same-sex couples every time you win a victory. And it provides a template. Do we want to look backward, or do we want to look moderate, forward-looking? And frankly, every time you get lesbian and gay marriage recognition, same-sex marriage, the world does not end. There never are any locusts. There are, as the Seventh Circuit said, more children who've been adopted can have families where both parents are locked in a marriage. And so more and more people are saying, well, there's some positive effects. This doesn't seem so bad. And where is the drama with all these negative arguments? It lowers the stakes, which I think is the big thing. That America is hyper dramatic. It's a very histrionic country. Oh, it really is. It's way too histrionic. The Europeans are much more sober and wow, these are really bizarre people. And probably were more bizarre than we ever were. And these other countries, if the histrionic Americans can sort of settle down and lower the temperature, then we don't want to be more histrionic than the Americans. So I think there's that as well. So I think it does have an effect. Well, we're one world. World is much more integrated, internet and these other things. So if you're in the People's Republic of China, I've been to China. I did the first marriage symposium in PRC, about 2005 to 2006, with the assistance of the Communist Party, right? And there was no one out. There were almost no one who admitted to be couples. Now there's a very thriving LGBT rights movement in China, People's Republic, Taiwan, of course, has done it. And, this is now conceivable in People's Republic, the world's largest country, et cetera, than it would have been 10 years ago. So that's a biggie. India is a biggie. These are big countries.
Let me ask you, and it builds a little bit off that argument and the point that was so prominent in the Seventh Circuit decision and then again in Obergefell about the benefits to kids of married same-sex couples. But the other reality, which also came up in that argument, is that we have many more families of heterosexual couples where the parents are not married, as well as gay and lesbian couples. And, sort of going full circle back to the Stoddard-Edelbrook debate, what's your take on it now? Marriage has happened. Has it been good for recognizing diversity of family forms or counterproductive because marriage is available and everybody else is not opting to be married, and so they shouldn't get those benefits and they shouldn't get those protections?
Well, the brutally honest answer to your question is that the jury is still out. And one reason I wrote the book, I was one of maybe the earliest, certainly the earliest academic supporter of marriage equality, and one of the earliest within the gayocracy. And I was not very high up in the gayocracy, but I was at the table often. And yet, I've always thought the Paula Edelbrook arguments were very smart, very sensible. And the book gave me a chance to reflect on the many ways that she was right. And Nancy Polikoff, who has made, Paula died in 2010, Nancy Polikoff, who's a friend of mine as well. So they've been right about a lot of things, including my response to them almost always was the very good point, but the gay marriage movement also generated all these alternative institutions, many of them open to different sex couples. Like in Colorado, designated beneficiaries. That's a complete product of this debate. And that's a wonderful template, but though not much followed. And so I was, of course, right about that. But then, Nancy would say, well, but these are all going to go away once you get marriage equality. And I said, not all of them. Well, I think Nancy and I were both right. A lot of them did go away, particularly a lot of employer domestic partnership. But California just expanded domestic partnership at the state level to include different sex couples, right? Colorado now has civil unions and designated beneficiaries for different sex, well, same-sex couples after marriage, right? Now, Melissa Murray, who is one of my very favorites, has hard-hittingly argued that, well, in cohabitation litigation, this is going to hurt us because Justice Kennedy, truth be told, wrote a Valentine to marriage. And it seemed to be like, oh, if you're not married, you've really lost something. And Deb, the kids have lost something. This is the point of your question, which is so right. There's just nothing but rightness about that. Okay, and in the book, what we do is we examine that and say it's much more mixed. That we agree with Murray, yes, ode to marriage, etc. But Obergefell is many-faced. It's also a statement of equality. Thank you, Ruth Bader Ginsburg. It's also a statement of equality and equal treatment. And what that means is, and indeed the New York Court of Appeals, the Maryland Court of Appeals, in cohabiting situations, are relying on Obergefell to expand, recognition of rights to cohabiting couples. Now I think courts that are more conservative are going to rely on Obergefell to close the door. But would they have opened the door without Obergefell? Don't think so. But that, I think the jury is honestly out on that. It's also out on the children issue. Second parent adoption. New York passed a statute. So it's hardwired in New York, marriage or no marriage equality. But will it make other states reluctant to do second parent adoption? Maybe. So I think the jury is out on that. And our book we have a whole chapter on family law. And we hold out as we believe in equality, but the template of the new model is what anthropologist Kath Weston called families we choose. And our argument is the state needs to provide frameworks and some degree of recognition for those families to work as well. And here's the other thing, is that there are two Americas now. The well-to-do America, still a lot of marriage, whether you're talking about gay or lesbian or straight, whatever. And then the America with less income, often less education, working class people, middle class people, as well as unemployed, they are not getting married. And they're having children very often out of wedlock. And America needs to be, the LGBTQ rights movement needs to be attentive to their needs as well. And I think that needs to be a major agenda. Now, the gayocracy is probably not with me on that, but you and I probably believe that. And I think academics should be absolutely adamant on that point.
Well, we are right at 1, and I want to thank you, but I also want to sort of end, if you quickly can say one more question from the chat, which was, what did you feel was the turning point? When did you know we were going to win?
Oh, I knew in 1991.
Oh.
I was the attorney. No, I was the attorney for the gay couple. Why did I know that? Now, I was surprised that we were vilified and President Clinton turned on us and I was read into the record and blah, blah, blah. I knew we were going to win because, honestly, Deb, I had a number of friends in D.C. where I practiced law and then was at Georgetown. I had a reading group. I had a number of friends who were committed lesbian couples, some of them raising children. My sister and her partner were a committed couple, and they were going to be raising children, which they've been doing for the last 20-some years. And I knew that these were valid families that would honor the institution of marriage. I knew that. Deb, I never had any doubt about that. So, and I was naive in thinking that you demonstrate that. Deb, in the case that I did in DC, we collected several dozen letters from religious leaders locally in DC and elsewhere saying, this is our interpretation of Bible, supports committed relationships, same sex. The Baker and McConnell marriage here in the Midwest, the Catholic chaplain said, yeah, this is a good idea. Jesus would be okay with this. A Methodist minister married them. This would be good. And they suffered backlash. Well, okay, I was very surprised by that. And I was very sobered. But no, I thought in 1991 that we would succeed. By 2015, yeah, I thought before then. After DOMA, no, I thought, no, not by 2015. No, I thought, wow, this is going to be a much harder slog than I thought it would be. But, you know, it was a slog that I enjoyed because I really enjoyed debating the folks on the other side. I got like the creme de la creme of the other side spokesmodel. Although I also debated Reverend Lou Sheldon, who was kind of like, these people are perverts and degenerate and diseased and all that. And that was not very edifying, though I did get to make the wonderful point in rebuttal. This was at the ABA convention, Lou Sheldon, Lord knows. And my rebuttal was, well, I think the Reverend and I are on the same page as regards lesbian marriages. That I think lesbians ought to be the only people to get married because they're the least diseased group in America. I'm not kidding. If you want to catch sexually transmitted diseases, hook up with a man. Well, he was not amused, though he looked very beatific. The attorney crowd, of course, was very sarcastic and amused. So he was the only, like, not very productive debate partner. All the other ones I thought were, like, really excellent. And it really enriched my intellectual education to debate opponents. And when I was doing the book, we would have dinners with, like, pro-life activists who were also involved in the marriage issue against my position. And, you know, I loved having dinner and respectfully having conversations with those folks. Phil Burris became a friend of mine, you know, the Paul Revere guy. I adore Maggie Gallagher. There's a whole chapter on Maggie Gallagher that I think is respectful. She blurbs the book, so she can't think that chapter was mean to her, I don't think. Okay, that's a gassy answer.
Thank you for a wonderful lecture and a wonderful conversation. And really, as you have gathered, there is a lot in the book. I mean, one of Bill's great strengths is that he can and does talk to everyone and have real conversations with them. And that's very much reflected in the book. So I really urge people to read it. And I wish you could see everybody clapping and thanking you, but I will just need to do it for them. So thank you so much.
Thank you for hosting. Thank you, the university, the law school for hosting, the Kinsey Institute for hosting, Professor Wittes for hosting, Professor Jay for thank you so much. It's always a pleasure. And we're going to continue in the smaller group.